For this podcast, we're going to be going over the actual role of the executive. It's going to be kind of split into two parts on this episode. The first part is going to be going over Article 3 of the Constitution. The second part is going to be going over the actual amendments to the Constitution, how they actually play out in the actual role of the judicial branch. And that's going to play actually together and how they interact, and both are going to show exactly what the role of the judicial branch is in itself and how it compares to the equal branches of the legislative and the executive itself. Now it's important to look over each of these three sections itself. The first is the judicial power of the United States shall vest in one Supreme Court and in inferior courts such as Congress may from time to time ordain and establish. The judges both in Supreme Court and inferior court shall hold their offices during good behavior and shall in stated times receive for their services a compensation which shall not be diminished during your time of continuance in office. Basically says they're going to keep their salary, and basically it just that's about just the establishment of their courts. Pretty standard stuff. That's not major things. Section 2, the judicial power shall extend in all cases in law and equity arising under this Constitution, the law of the United States, and treaties made or shall be made under the authority, to all cases affecting ambassadors and their ministers and consuls, to all cases of admiralty and maritime jurisdiction, to all controversies to which the United States shall be a party, to all controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of same states claiming lands and under grants of different states, and between a state or citizens thereof and foreign states, citizens or subjects. Basically, that paragraph right there just outlines the actual power and what their judicial branch is governing over. It continues down here in cases infecting ambassadors, all our ministers, consuls, and those in which a state shall be the party of the Supreme Court shall have the original jurisdiction. In all our cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions under such regulations as the Congress shall make. That's just basically establishing a level of a level of a power structure before you get to the level of the Supreme Court. So not all things start at the Supreme Court level, and certain things can actually be raised at lower levels if they could actually be solved at those lower level positions. A trial of all crimes except in case of impeachment shall be by jury, as such a trial shall be held within the states where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such a place or places as Congress may by law have directed. This is basically judging where the actual trials shall be done, and that only concerns location. Section 3. Treason against the United States shall consist of levying war against them, adhering adhering into their enemies, giving aid or comfort. No person shall be convicted of treason unless on testimony of two witnesses to the same overt act or confession in open court. That's basically giving the definition of treason, which is a very, very key thing, because treason must be done in, as it says, a court system, which would be dealing with the judicial branch. And then down here, the Congress shall have power to declare punishment of treason, but no attainer of treason shall work corruption of blood or forfeiture except in the life of the person attained. And that's basically the point of that, is basically kind of establishing the whole idea and the whole system. But now the big part is where the actual judicial branch is governing is they will govern over the constitutionality of the actual laws, which follows under the roles of the executive and legislative, of if those are overreaching in what the actual direct stated duties are within the Constitution. And basically, if they are not directly stated in the Constitution itself, that branch does not have that authority. Now, in a constitutional system, they do not give they are not meant to give deference. Now, we've seen cases to where the judicial is giving deference in those cases. And another point is that we're seeing with it, that's another negative point, is what they're calling precedent. This is basically where something is existing for a long time. So they're saying we can't pull it, because if we were to pull it, it would be it would have a negative impact on people's lives. Now, when we're seeing the idea of it is, if it's essentially viewed as an actual infraction of people's lives, it was actually never seen before, but never noticed at that previous point, it must be pulled. I mean, based on the point of precedent, we could actually claim that slavery, which would go under the 13th Amendment, which is not under the Bill of Rights, but it's directly after it. It's not far after it, and we can claim that slavery should never have been written into the Constitution as being outlawed. But the fact is, we do have it there. Based on precedent, it should have they could have made the claim that it should never have been in there. Now let's go into the actual individual parts with it. Now, when we actually look at the Constitution, it should be very, very directly as written. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. What that refers to is not that there can't be religious symbols in public, but that the actual government itself cannot prohibit you from practicing your own religion, nor can government establish a religion itself. This means the arguments made by the Freedom From Religion Foundation and other progressive atheist groups are completely illegitimate, because it's not that society has to be free from religious symbols. It's that the government cannot establish an actual religion. You can have any society can actually have religious symbols. It just cannot establish an actual religion itself. A religious symbol does not fall under that point, because you're not using by force anybody to do that. This means you can actually erect something of the Ten Commandments, and in a public manner with it, you can do any of these things, because you're not establishing a public religion. Because such things within Ten Commandments, Ten Commandments are actually used as a basis for not only every religion under Christianity, which is both Catholic and Protestant, plus there's many other ones that don't even fit under that for non-denominational and other variants. You also have Judaism and all of the variants under Judaism. So that would actually essentially, that would not be one religion. And technically it does not forbid you, because you're not, an actual symbol does not forbid one from free exercise thereof. Even if you're an atheist, the symbol of the Ten Commandments in public does not forbid you from being an atheist. And then another one is abridging freedom of speech. There is this is another thing. They cannot. It's very, very blunt. That means the ideas of the FCC and limiting what can go on television, that's not meant to happen, or what goes on radio. They're not meant to essentially get in the way, and they can't say, oh, we don't want this to be on radio, television, any of this with it, regardless of what reason they want to give. They're not meant to do that. And it says, or the press. Now, government is not in the business of declaring who is the press. And we've seen people like Dianne Feinstein want to declare who is part of the press and who is not. Now, if you look at historically, people like Benjamin Franklin did not want the government to declare who is the press, and this is why specifically why they put these rights like this in there, because the ability to speak out against one's government was a key right, and this is the way to do that, being able to do it through the press. And such outlets as social media should be an outlet of citizen journalism, and they should be able to speak out in such a way. And this is why we've gotten to some aspect of being able to talk in that way. And when we're talking about the next one, which is the right of people to peacefully assemble with it, well, that's kind of interesting, because people shouldn't have to, a lot of times people shouldn't have to file an application for that. And we shouldn't have to have basically people violently attacking people who are peacefully assembling. And when we have these other people that are on the opposition that are actually just using violent attacks, which are always socialists or communists that are calling themselves anti-fascists, and doing this, they're basically, or other left-wing groups, all they're doing is basically or these feminist groups, and they're basically, all they're doing is, or you get these alt-right people who are basically just toss-offs from the left, and they're not people that are actually looking for peacefully assembling, and that's actually not covered under the groups, but they're actually just looking to riot, and that's not a right. And there's many other groups that fall under that, to peacefully to petition the government for redress of grievances. I mean, this is one that's it's another point, and this is what we need to make the legislative the judicial branch understand, that these need to be upheld regardless. And here's another thing on the second one. It's very, very important, because the term militia is a very, very important term. Because if we look actually in what we saw on the within the role of the executive, the militia was not termed as police, because they would never have sent off police, because it would have left it would have left basically the United States as some type of unruly mob without police. So we know that the militia did not mean that, and if it were police, they would not have needed any type of training for uses of guns, or uses of guns in an organized manner. they would needed light training at best. So it says a well-regulated militia being necessary for the security of a free state, and the free states meaning the individual states, the right of the people meant individuals, to keep and bear arms shall not be infringed, and the shall not be infringed meant any type of legislation. And the militia was referring to individuals within the actual individual states. And this is something that's actually been infringed on for basically, we're talking for quite some time, actually basically since the Progressive era. And they've been looking on these infringements. We've even seen it before. And because we're talking slaves didn't have rights to guns, and we had and these were actually legitimate human beings. And if they're going to be treated as human beings, they need to have the right to defend themselves. And that's why the Second Amendment's right there with it. And when we see some of these judges that basically try to change out the meaning of militia to meaning police, which you could see in plain English that it didn't mean it when we look at the roles of the executive and legislative in the previous forms of in the previous sections of the Constitution. You could see plainly that it did not mean that. This means that basically any type of regulation, because it says shall not be infringed, this means you can't make any regulation on it. Shall not be infringed is very, very blunt. You can't make. This means anything the military has is the people have to have, and this is basically, and it says security for a free state. Now the state is not the United States of the country. These are actually free individual states within the United States itself. Now you go on to number 3 is no soldier shall in the time of peace be quartered in any house without the consent of the owner, nor in the time of war, but in the manner prescribed by law. That means unless there was an actual law written, there was actually basically within a constitutional manner, which would be done with some type of voluntary consent, be done with it. But because we're talking that most states have laws written that basically do not allow for this, because they state that they cannot steal, no person can essentially take property or seize property without some type of compensation, even if it's even if it's quartering in property, they cannot do that without compensation. That's why they can't. That's why this would be a very, very stiff law, and they could, even if this law had been, even if this amendment had been repealed, it wouldn't do much good, because the fact is that's why they wouldn't even bother to repeal this, and that's why that has not even been challenged. Now we go down to number 4, and that's why when it comes to the Supreme Court, the Third Amendment is really irrelevant. Fourth Amendment has been a big topic. The right of the people to be secure in their persons, houses, papers, and effects. Now the term effects refers to anything else that doesn't fit under persons, houses, or papers. This would mean that basically and it says against unreasonable searches and seizures shall not be violated. No warrant shall issue upon probable cause supported by oath or affirmation, particularly describing the place to be searched and persons or things to be seized. This means that anything done by the NSA, because this does specifically say that it is not, you cannot do bulk warrants. This means that basically what the Supreme Court has been doing by allowing a secret court, and what the judicial has done by allowing the the FISA court to exist is essentially they have essentially violated this. The FISA court, instead of just rubber stamping everything, they should, once they without getting these anytime that they want anything more than a single person, what they should be doing is they should be rejecting it if it's any more than a single person. If they want to do something in secret, fine. But the fact is they need to essentially produce something that would be an individual warrant. Now, they could do that validly with it, and they could actually do that in an actual traditional judge. But the fact is they want to use the FISA courts because they could essentially, they're using it to validate their violation of the Fourth Amendment, and they think they can do it lawfully. Well, the fact is the judicial branch should be actually stepping in and blocking every one of those, stating that it is essentially a violation of the Fourth Amendment. And they should be stepping in every time. I mean, if the judicial branch had any spine, they should be stating that the NSA, which is under the executive branch, because we're talking about co-equal branches here, should be stepping in every single time. Now we go under the fifth. No person shall be held to answer for a capital or otherwise infamous crime unless presentment or indictment of a grand jury except in cases arising in the land or naval forces or in militia or in actual service in time of war or in public danger. Shall any person be subject for the same offense to be twice in jeopardy or of life or limb, or shall be compelled in any crime case to witness against himself or deprived of life, liberty, or property without due process of law, shall private property be taken for public use without just compensation. Now, this is the whole thing this is the whole thing that's kind of interesting with it when we're talking about civil asset forfeiture, essentially where they're basically taking this stuff without actual due process, and they're starting to essentially at least adjust to that point, and that's something the Supreme Court's finally addressing. And what we're seeing with it is they're actually taking because we have been seeing where they have been doing things of eminent domain in this case as well, where they've been taking and claiming public use for private property taken for public use, but the public use has been giving off to major businesses like Pfizer and other companies like that. Well, that doesn't fit under the public use because you're just giving from one private user to another and claiming public use. And that doesn't fit under the actual idea of what public use technically is, because there's no actual public use for that property. Because if an actual citizen of the region actually entered that property, they would essentially be arrested for entering private property, because that does not become public property then, and that's the whole point. Amendment 6: in all criminal prosecutions, the accused shall enjoy the right to a speedy trial by an impartial jury of the state and district wherein the crime shall be committed, which the district shall be and that's basically about right to a speedy trial and being given counsel for the defense. Basically, that's really kind of illegitimate when it comes down to the judicial department in the suits of common law, controversy of. That's basically given right to trial by jury for Amendment 7. Now here's a key one with it. Amendment 8 is excessive bail shall not be required, nor excessive fines imposed, nor accrual in usual punishment. Now they love to now what seems to be is they love to tend to look at the cruel and unusual punishment on the Eighth Amendment, but they tend to ignore the first part, is excessive bail shall not be required nor excessive fines imposed. And what we're seeing is that they're not looking at that part. Now, what would not be excessive fines is such as if, like let's say in the Jussie Smollett case, if they made him directly responsible for all the costs that were accrued for the case of the fake hate crime case and what it actually cost the city. Now that would not be an excessive fine if that were actually the punishment. Now what we see with some things of the excessive bail is we'll see excessive bail things that are basically used to basically keep people in, and this the judicial thing is massively guilty of this. They'll do this with basically people that they know. I mean, we'll see people like even like people like Roger Stone. Roger Stone doesn't have a passport. Roger Stone doesn't. Roger Stone's wife is virtually deaf. So the idea is that he's not going to be leaving anywhere. He's a massive name. People are going to see where he goes. He's not going to go into hiding. So the idea of actually even requiring bail on someone like him would be illegitimate. But we're going to see people like, we see cases like that where they are going to put bail really high because it's a political case. But then we see, but what we're seeing with it is they actually put, we'll see these horribly high bails, and it's just, this is not constitutional. Another one that ends up getting ignored by the actual courts, by the judicial system, I should say the judicial branch, is the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the 10th Amendment is the powers not delegated by the United States Constitution nor prohibited by its states are reserved to the states or to the states respectively or to the people. And these two specifically need to be understood. Is that what they don't understand is this falls down to a lot of the branches if they don't understand that the Constitution is not a limit on the people, but rather a limit on the actual government itself. Then when we start to go over here, there's only a few ones that are actually very, very key. And what we see that is we see the 13th Amendment, which prohibited slavery and indentured servitude. Now this is key. This is where they should actually state that, which means indentured servitude refers to, they need to make this announcement, is that it forbids even indentured servitude to the government, and you cannot, it means no forced labor. We can't force somebody to actually serve you, and regardless of what the case is. And the only exception, it says, except by punishment for a crime, and it states right there, except by punishment or crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And that's specific. beyond that, we're talking that there's some key things with it that need to be understood. Is that other things when they come to the courts is that when we saw the thing of the point of the ban of liquor and the elimination of such a ban, when it was repealed, that's key with it, because when we look at the actual war on drugs, that's another one that they need to essentially examine, and that means the DEA needs to essentially be eliminated, because all they're doing is that's their job. So if it took a constitutional amendment to essentially ban that substance, we need to understand that that's the same idea. The same idea needs to be applied, because you got to think these were the same materials that were essentially used in the United States itself, and they need to essentially go over and realize that that's what was going on. And it doesn't matter it doesn't matter if they say, oh, but it's for the public good. It doesn't matter if it's for the public good. They need to understand that it's that's an illegitimate argument. It's because there's a lot of things you can say are bad for people, and people still have access to. I mean, you got to think there's fast food is bad for people, but we don't create we do not create a law to basically ban fast food. I mean, that would be unconstitutional, and if they let that through with it, that would be even worse. And then this is where they need to understand what is constitutional and what is unlawful, and they need to eliminate what is not constitutional. And then when we see this, we see the fact is they need to understand this, and this is what we're finding. We're finding that basically what they're doing is they're doing this basically kind of rolling over and kind of letting these other two kind of having their ways on these things. Like when they're passing stuff, they're kind of rewriting over stuff with it, making sure it kind of fits to some kind of halfway constitutional point. Now, we have put in people that are good. We have put in one that's good, which is Neil Gorsuch. I have been quite disappointed with Kavanaugh so far. I feel that his idea of precedent is a very, very negative thing, but expecting he was going to replace Kennedy, I mean, you get what you get. And I think the idea of what they were bringing out in this whole big outrage was completely blown out of proportion. But when it comes down to the actual role of the judicial, I think what we got to realize is they need to essentially view the two parts. View what it says directly in the Constitution itself, view what it says in the actual amendments as they're actually written, and realize that basically people's rights do not end there, and the government's role ends exactly where they actually state there. That's the whole point. And you can't write, you have to stop the government from writing these bulk warrants, and these things need to stop. You can't use the excuse, oh, it's a different time. That's not an excuse. There's no excuse of, oh, it's a different time. That doesn't fly, because the fact is, when we view the idea of terrorism is, I mean, you can basically is historically, I mean, they have what it called, they have stuff back to what they consider as emergencies for terror back in the back in France in 1793. You have historically with it, we have they can trace the roots back to 1 AD for terrorism. So this is not exactly something that's new. And it's so when they're stating that we have to do it because of terrorism, well, I hate to tell you, but this is something that's been going on for basically over 2,000 years, if not more. And when we see that, we see the idea of that is, we go back to when it was first used, is we're talking when it was first used was actually in 1794 was the actual first term of it being used. But when we actually look at the first time that it actually happened, was it goes back all the way back to the 1st century. And that's a long time ago. And when we look at the actual path of actual incidents, is we could see the actual thing, it kind of follows an actual path of the more intervention we have, the more incidents and deaths we create. I mean, this is basically, it follows basically pretty much almost an exact copy of what we see. If you look at the map, I mean, if you've been able to follow it, and that's pretty much what we see. So for those who state on that point on the Second Amendment, or sorry, on the Fourth Amendment, of it's a different time, it's, if you look at that, you'll see the fact is that basically it follows the amount of, the more intervention we have, and the more we step it up, the more incidents and the more attacks we have. It'll actually downsize. It actually downsizes when we actually look at the legitimacy to it overall. And that's why when we look at constitutionally, is it's best off to actually just stay with the Constitution itself in a very, very strict manner and not start to go very, very loose. And the role of the judicial branch should actually be for that actual point. Now, if you like this, subscribe, click the notification bell, share it all the way on social media with your friends, and share it publicly, and get all of them to subscribe. I'm only sitting at 18 subscribers. Please see if you can get anybody else to subscribe. And I will see you guys later tonight for a live stream here on YouTube. Bye, everyone.